Andy, we're winding down our cram for the exam segments, and one of our favorites left, the Supreme Court of the United States.
Article 3 of the Constitution, really important because the Constitution dictated for the first time national laws. And if you're going to have national laws, you need national courts to interpret those laws.
Undoubtedly, we are a nation of law, Andy, so we put a high premium on our courts. Let's not forget we have a dual court system, both state and national courts, which again represent our federal system. Separation of power between national and state governments. But Andy, when we look at the courts, we invariably look at the highest court, the highest appellate court in the land, the Supreme Court.
That's right. The Constitution gave Congress the power to create the federal court system. We have district courts at the bottom level. We have circuit courts of appeal at the middle level. But the top court is the Supreme Court, made up of 9 justices nominated by the President and approved by the U.S. Senate.
And of course, that number can be changed. The Congress determines the size of the Supreme Court. We've kind of grown accustomed to this 9, Andy, and interestingly enough, as we talk about the Supreme Court in the modern era, we ultimately talk about politics, a word that we thought was immune in our legal system. But the Supreme Court is not above politics.
No, they gave federal judges lifetime appointments where judges could serve for the duration of their life to try to make the judicial branch less political. But we know that the judges have to go through a very political process to get their job. And so when they get that job, we also know that they have political ideology.
Well, what makes this scary, Andy, is with the Supreme Court now as an extraordinary amount of power because they have judicial review. In the court case Marbury versus Madison, John Marshall, that old Supreme Court justice, essentially empowered the Supreme Court to rule all acts of government unconstitutional if it be their will. And Andy, this has given the court tremendous power. So as we've seen the court grow increasingly political, those presidential appointments become increasingly more and more important. Because as we look at the court even today, we notice conservative blocs and we notice liberal blocs.
And we know the court's important because a lot of times the laws that Congress writes are vague. Heck, even the U.S. Constitution is vague. And so interpretations of that, whether it be the Interstate Commerce Clause and what does that really mean, or the Necessary and Proper Clause and how far can that go, the Supreme Court and federal judges are crucial in how the law and the U.S. Constitution are interpreted.
Well, Andy, I guess what you're talking about is how do judges make up their minds? There really are two in the textbooks, Andy, judicial restraint and judicial activism.
Well, we know that judges look at the facts of the case. We know that judges look at stare decisis, meaning judicial precedent, to get consistency. We also know that judges look at what was the intent of the law. Besides just the letter of the law, what was the intent of the law? And intent is definitely where you get some range of personal interpretations.
Well, it reminds us of that important Latin word, stare decisis, Andy. As a nation of law, we really hope that our justices build on previous precedent, previous court decisions. But here's where we ultimately measure the activism in our courts. The number of times they deviate from previous cases. Andy, this is not something just for liberals or just for conservatives. We see activism from both political blocs.
That's right. And so again, remember that even though justice is blind, these 9 justices tend to be very political. We know that they tend to be nominated from top law schools. They a lot of times had judicial experience. Or in Elena Kagan's case was Solicitor General. She actually argued cases before the Supreme Court. And we know increasingly presidents are under pressure to nominate younger justices. And when we say that, we mean justices in their mid-50s, because it gives a president a chance to extend his legacy beyond his 4 or 8 years in office, since, again, federal judges can serve for life.
Andy, one last topic here. Let's talk about how cases come to the court in the first place. We know there are literally thousands and thousands of petitions that come to the Supreme Court every year, but in the end, every term, it's about 80 cases that they render decisions. How do they decide upon those 80?
Well, it's based on the rule of 4, and the Latin phrase for that is writ of certiorari, or writ of cert, where it takes 4 justices to agree to hear a case. Now remember, there are 9 justices. It takes 5 to get a majority opinion. But in that American democratic principle of giving the minority the chance to be heard, it only takes 4 justices to agree to hear a case.
Well, speaking of being heard, we know the Supreme Court doesn't just make decisions, they write opinions. And after every case, after each of those 80 cases, the justices themselves write out their rationale. The court opinion, of course, is written in the majority opinion. But it's not uncommon, Andy, for a judge in the majority to say, I agree with the decision, but I don't agree with the rationale. And that's called a concurring opinion. And then those justices who disagree with the court opinion, they write what's called the dissenting opinion. Andy, we've talked about the Supreme Court and how important the law is, but we've also noticed that the political thicket has now grown inside the Supreme Court temple of justice, something you and I, each citizen, need to keep a watchful eye on. What's going on inside the news? We know. We're two teachers. No fancy words.
No fancy suits.
Plain talk about issues you need to know.
Just in time.